Welcome. My name is James Boland, and I am the founder and president of the Australian community. Today, we're speaking with Zjantelle Cammisa Markel. Zjantelle is the principal of Cammisa Markel, an immigration law firm based in New York City. Zjantelle, welcome.
Thank you, James. Thanks for having me again.
Well, it was only last week, I think, we recorded our February update. Of course, the good news is that premium processing for E3s is now happening.
Yeah, I love how we recorded the February update saying that, premium processing was on its way, but we didn't know when. And then next thing you know, bam, out it came. So that was very exciting.
I think a word of warning before anyone with an E3 rushes out to file an I-129 and pay their $2,500 for the premium processing. I think there's a word of caution there, because what we want to do in the discussion today is talk about for whom it makes absolute sense and for whom it would be the worst possible thing to do for them. As we said before, premium processing, it isn't a silver bullet in every situation. And, used the wrong way, you might actually end up shooting yourself in the foot. So, Zjantelle, perhaps we could talk first about where the premium processing makes absolute sense.
Firstly, you're only going to use premium processing if you're filing an I-129 petition in the US. So just in case anyone's not aware, premium processing does not apply to when you're consular processing at all. So I think maybe it's prudent for us to just quickly go over what the I-129 is. The I-129 is the petition that you prepare to file for an E3 from within the US. You're filing a petition with USCIS. And you can do that either with an extension of your E3, a change of employer for your E3, or a change of status to E3 is also filed on an I-129. Sometimes people think that to change status to an E3, they have to use the I-539 because that form is called a change of status, application to change status, but just want people to be aware that if you are changing status to E3, you do use an I-129 form, which is for the E3 petition. So now the E3 was not historically included as an I-129 that could be premium processed. The I-129 form in and of itself, and when people go through this process, they will see that form is the one form, and it's used for multiple different categories. So it's the same form is used for H-1Bs, for O-1s, for P-1s, for L-1s, and for E3s. So now if you're filing your case with premium processing or even just that you're filing an I-129, I think we'll first talk just about the I-129 and how it differs from consular processing, because a lot of our viewers are more familiar with getting their visa at a consulate abroad. So how it differs is that you're going to be filing this petition with USCIS rather than making an application at a consulate abroad where you get to argue your case in front of an immigration officer, and that department is Department of State. So you're actually now dealing with a very different government agency to when you normally go to a consulate abroad. USCIS, the division that will receive the E3 petition, is the same division and consular officers that typically adjudicate H-1B petitions. So they've been trained on how to adjudicate an H-1B, and now they're also adjudicating E3s. And the reason for that is because the E3, the requirements for an E3 are very similar to that of an H-1B, meaning the person has to be employed by a US employer, receiving an employment with a US employer for a position that is a quote unquote specialty occupation. And what they mean by specialty occupation is that the position that you're filling requires a degree in a specific field or a field very closely related to a specific field. And then you will be requesting, again, like the consulate, you're requesting 2 years. And the H-1B has a similar requirements. Also, the H-1B has the LCA requirement, like an E3, whereby the employer, while petitioning for the employee, has to attest that they will pay the prevailing wage for this employee. So when you file with USCIS on an I-129, you're opening yourself up to the potential for a request for more evidence. And there's a higher risk of that when you file it with the USCIS because they don't have that at the consulate. And the reason for that is that when you file an I-129, you need to disclose more information about the company and about the role. So they're going to be looking at the company more closely. We have to disclose the year the company was founded, how many employees the company has, the financial revenues of the company in the last financial year. Depending on how that looks can affect the adjudication of your I-129. In addition to that, the position that you are filling, they're going to look at, is this really a specialty occupation? Is this an occupation that requires a degree in one specific field? And then when you file an I-129, they also look more closely to the wage that the person's is going to get paid, and the LCA, which wage level it was filed under. So typically when people go to the consulate, there's not as, you don't have to disclose the size of the company, the finances of the company. You don't need to, they typically don't question you too much on the wage level that was used for your LCA. Whereas at USCIS, they can do that and will do that if they think that you shouldn't be placed at wage level 1 and you filed at wage level 1. If the company is young and didn't make much money last year and has few employees, they can come back with a request for evidence that's called a VIBE RFE. They want to check that the business is really validated and operating. And also the other thing, when there's not many employees, they might suspect that the beneficiary won't be doing only their specialty occupation duties. So they might say, well, there's only 3 people at this company. Who's answering the phones and doing business development and doing, these other things while you're supposed to be the IT person and only doing IT duties, for example. So it's important to really look at your case with an immigration attorney to see the strength of your case for an I-129 filing, regardless of whether you're filing premium processing, and especially if you're filing premium processing, because when you're filing premium processing, you're paying that extra $2,500 to get a response. So it's not necessarily an approval within that time. So in the 15 calendar days, you could get back this massive request for evidence. When you get the request for evidence, they typically give you 90 days to respond to it. And if you get a request for evidence that's about questioning whether this job is a specialty occupation, for example, those are really cumbersome to respond to. They're often asking for things like, we want to see that anyone that has previously been in this role had that same degree. Please provide us with copies of that. Please provide us with wage data and payroll evidence of the employees that are actually at the company. Please show us the job ad that requested that specific degree for that role. Please show us that other companies that are similarly situated require that same degree for that role that you're wanting to hire this beneficiary under. So it can take a long time to respond, and USCIS is no longer bound by that 15-day processing time if they give you an RFE. So that's really important to consider, because if you don't have too strong a case, then you're filing premium processing just to get this RFE quicker than you would have got it if you didn't file premium processing. So where you would particularly question whether you want to file premium processing is especially with the cases that are an extension with the same employer. Because if you're an E-3 and you're extending with the same employer, you automatically get 240 days of continued work authorization while that petition is pending. So if your case takes a long time to get adjudicated, and you don't have a particularly strong case with an I-129, it might be better not to file premium processing so that you can not get that RFE so quickly for that case.
And also too, you might in that time, that 200 odd days, get a consular appointment and then go and get your E3 at a consulate somewhere in the world. So it gives you some time to find an appointment.
Yes, and in fact, a lot of our clients have used the I-129 filing as a way to remain and continue working until they do find a consular post to be able to consular process their visa. Also, because eventually you're going to have to process your visa at the consulate abroad anyway, because filing the I-129 in the US does not give you the E-3 visa in your passport. It will approve your status in E3 so that you can continue living here beyond your current I-94 end date, and that you can start working. If it's a change of employer, you can start working with that employer, or it's affirming that you can continue working with your current employer, but it doesn't give you that sticker in your passport. So the next time you travel internationally to be able to get back into the country, you have to do the visa process all over again at the consulate abroad. So in essence, if you're going to travel internationally within the next 2 years of filing that I-129, you're basically doing your E3 application twice, once as an I-129 and then again at the consulate abroad.
So Zjantelle, thanks for clarifying the I-129 versus a consular appointment. But perhaps you can talk about what are the quote unquote slam dunk E3 applications and those positions maybe that might get the request for evidence.
Absolutely. So I like how you say slam dunk. I wish they were all slam dunk. But typically what we would refer to as a slam dunk E3 or is if the specialty occupation is one that could only be done with one specific degree. So examples of those occupations are lawyer, architect, dentist, engineer, doctor, any specific type of doctor. So those, you cannot be a lawyer without a law degree. You can't be an architect without a degree in architecture. So in those cases, they're not going to be issuing a specialty occupation RFE at all. So that is the perfect combination for filing premium processing. And I think the cases that are primed for premium processing are a change of employer E3 petition where the occupation is undoubtedly a specialty occupation. So in that, it's a no-brainer. You pay your $2,500, you know that in 2 weeks you're going to be able to start working for your new employer because there's nothing jeopardizing your case. The only way that might not be slam dunk is if the employer is a small company, has one employee, and your wage is at wage level 1, then maybe it's not so slam dunk. But if all the stars are aligned, it's a great employer, the salary is, hopefully at least wage level 2, you're one of those slam dunk professions, file away premium processing, your $2,500 will not be a waste of money. It'll be great.
And perhaps those that aren't so slam dunk, what sort of examples would that fall under?
Not so slam dunk are definitely hospitality roles. USCIS definitely attacks hospitality roles. Funnily enough, one that you wouldn't expect, but that gets criticized a lot with USCIS is a CEO role. And the reason why USCIS will almost always come back on a CEO role and say, well, CEOs could have any number of kinds of degrees. You could be a CEO with a marketing degree. You could be a CEO with a bachelor's in business. You could be a CEO of an IT company with an IT degree. So they will almost definitely come back and say, why do you specifically need this degree for your CEO? So if you're a CEO, that's a tough one. Marketing can sometimes, market research analysts that gets attacked by USCIS for specialty occupation. They're the main ones.
Zjantelle, final question. Are there any scenarios where an employer files an extension with an existing E3 where premium processing makes sense?
That's a great question. And I know you're asking that question because we earlier said that that's the group that least benefits because they already get 240 days of continued employment. So there are 2 scenarios where I think that it could be beneficial. The first scenario I'll talk about is because it can be beneficial from filing premium processing at the outset of the case, which is if you have a spouse that also needs to extend their E3D status and in conjunction get a new EAD. So filing the E3 with premium processing could help speed up the processing of the E3D and EAD, which right now is very severely backlogged. So what people need to know is that if you file your E3 extension premium processing, it will get approved in 2 weeks, but the E3D will not get approved at the same time as the primary E3. And this is really important because if people expect that, they'll be supremely disappointed. But they can't process the I-539 extension for the E3D or the EAD until the E3 extension is approved. So now you're getting that approved in 2 weeks. So once they get to the E3D and EAD, that first part has happened. So it could speed that process up for the E3D and EAD of the spouse. But just know they're not going to get it in 2 weeks with the primary. And the reason for that, James, is because when you file an extension of an E3D in the US on an I-539 form, and that's the only way to file it, the person will have to, the spouse will have to go to a biometrics appointment for that to be adjudicated. Biometrics are currently backlogged, so they're not getting that in 2 weeks for sure, sometimes not even until 3 months later. And so they have to have the biometrics. Once they have the biometrics, that I-539 gets adjudicated, and then the EAD. So there was a second time when it could be useful for people that are filing an extension with the same employer. So those are for cases that have already been filed and you're coming close to the 240-day mark. So now if you're coming close to the 240-day mark, you might want to 14 days before that or 15 days before that upgrade your case to premium processing to try to avoid a gap in employment. Because if you hit the 240-day mark, and during this pandemic, we have seen cases that were extensions with the same employer filed regular that have taken up to 8-9 months to get approved. So if you're nearing that 240-day mark, you can now file a premium processing to minimize that gap, because otherwise you would have to stop working at the 240-day mark.
Well, Zjantelle, I think we've covered that point pretty convincingly. But I would like to say that for anyone who is listening that is considering premium processing, do seek legal advice, because as you can appreciate, there are many moving parts here. You're going to need to have someone who has a very good understanding of which E3s will go through, as we say, a slam dunk, and those that may not. So the last thing you want to be doing is spending an additional $2,500 to find out within 15 days that it's not going to be an easy process to get your E3. And I think the next premium processing we're waiting for is the EAD, isn't it? That's the sort of the next piece.
The next piece we're waiting for. So I'll add a little tidbit here. I think that the reason the E3s came out first is because they already had premium processing programs set up for I-129s. So it was easy for them to just say, okay, we're adding the E3 to this category. So there was already a process in place, which was the $2,500 you attach it to I-129. Now they've just said, okay, we're adding E3s to this category. So the other ones that they announced were coming out with the 539s and the EADs, which that's going to really benefit our Australians, James, like really. And so I think that hopefully that will come next. And the fact that the E3s they came out, I think that the 539s and the EADs are forthcoming. So that's going to be really exciting.
Well, again, Zjantelle, thank you so much.